tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Season 7, Episode 6 of Fire Away. Today, I'm really excited to be joined by Murray Miskin. Murray has been a practicing lawyer since the early 1980s, practicing in a number of areas, including personal injury, insurance litigation, employment law, and wills and estates. And as if that wasn't enough, Murray is also an experienced arbitrator and mediator. So really looking forward to the discussion. Murray, welcome to the show.
Thank you. And today I was practicing criminal law. In a matter
I should have added that to the
2
list.
days, it was supposed to take 2 hours. That's what happens when you go to court. Even virtual court can be quite inefficient.
So one of the things we're going to get to, but we'll get to it now, is why we're doing this on a Wednesday instead of the usual Tuesday for Fire Away, which what we're supposed to do. So we're going to talk a bit about the inefficiencies of the court system. Maybe you can take us through what happened over the last 2 days.
Well, I have a client. He turned himself in at 7 a.m. Because the police wanted him, and they said we'll have to take him in custody for a bail hearing. But if he gets there early enough to the police station, like 7, the court starts at 10 and he should be out of there by 11. Anyway, we went till after 5 o'clock and it didn't get finished, and the court abruptly adjourned when it was closed. And then we had to start all over again today with a different judge and a different prosecutor, and we finally got it done at 3:30 p.m. So costly form of litigation. The main problem with these things is you can have 60 cases on the list. If you have a mediation or an arbitration, there's no list. You're there. And that waiting time is expensive no matter how you handle it.
Well, that's one of the things that we were going to come to, but it's a point I often make. In addition to how long it takes to get to a trial or to a hearing, people often talk about the day in court and look at a typical, yours is not a typical day in court that you're talking about, but look at a day in civil court. You're supposed to start at 10. Often you don't start till 10:30 or so. Often there's extra breaks or extra long breaks, an extra long lunch, and you often end up finishing early. And it's not, I'm not critical of the judges. They are overburdened and overwhelmed, and they're often dealing with 4 or 5 different cases at the same time. But your day in court often ends up being closer to 3 hours.
Or longer. I was once in motions court, and it actually went till 11 p.m. from 10 a.m. because it was the end of some system that they were doing. They were changing to a new system. And the judge, who was about to retire, was generous enough to give his time and say, we're going to get through this list. There were 45 cases. And we got through the list. I came back after dinner and went through another day of it. And we finally got reached about 10:30. And so that was a long day too.
Of that day, when you were in court till 11, how long was your matter actually being dealt with?
Well, actually, I had 2 of the matters on the list. So I got one of them done in the late morning, and the other one got us into the evening. But you can leave occasionally. Sometimes the court will say, come back after 2 o'clock when you're there in the morning, and they know you're not going to be reached. But other judges can be kind of mean and make you wait and not leave. Say, well, something might come up and we may deal with you anytime, so stay in the courtroom.
Yeah,
and makes you
so
afraid to go to the bathroom.
You can spend hours and hours there, and your case is 10 minutes or less, especially if it's a set day type of thing. So it's a perfect example of the inefficiencies of court, whether it's civil or criminal for that matter. Way back when, I thought I was going to be a criminal lawyer, even all the way through law school. I did the criminal intensive program at Osgoode Hall. And this, of course, isn't my naivete. When I was a teenager, I was watching shows like LA Law, thinking I'd be doing, capital punishment cases, of course, not recognizing that we don't even have that in Canada, but that was the goal for a long time.
Yeah, I think you went to school after capital punishment was abolished in this country. And I can tell you too, I did a lot of personal injury trials, mostly early in my career, before the days when everything settled at mediation. And with a jury, and almost everything had a jury, it takes twice as long, at least, to go through a trial. plus jury selection and everything else. So it's
Mhm.
and then the decision is totally unpredictable and not necessarily logical, which means I lose
You hit on
sometimes, but
you hit on
win
another
most
point we're
win
going to
most.
come to, which is the
Yeah.
unpredictability of decisions, whether it's a judge or jury for that matter. So I want to take a step back for a second because as I mentioned in the intro, I mean you've been practicing law since, is it 1981?
Yeah, called the bar in 1981. I graduated law school in 79. I was very young.
Nice. Yeah, you must have been what, about 11?
Not actually, well, a little older than that. Yeah, but I was called the bar at 25.
That's pretty
So
impressive. So,
yeah,
so I was inspired a couple of days ago. I was listening to one of my one of the hockey podcasts I listen to because you can't only listen to law podcasts. And Mark Messier was the guest, and people who know me know that I have idolized Mark Messier since I was a kid. He's still my favorite hockey player. But they were asking him about how the game of hockey had changed since he started. So I'm gonna put you in the same group as Mark Messier, which I don't know how often that happens, Murray, but you can talk about how the practice of law has changed over the last 40 plus years.
well, it used to be the judges were a lot older than me. Now they're a lot younger than me. But I think that's not really a change. I think it's just that I've gotten a little older. But they definitely are appointing people to the bench. A lot more women, some Indigenous people. It's a much more balanced thing. There, it used to be whenever you went to court, there was a fear of the judge. Like the judges were really scary and they were mean and they said bad things to you. And somebody's talking somewhere. I don't know where that. But anyway,
Yeah.
often articling students would leave the court after appearing before Master Sandler or somebody like that in tears because he was so mean to them. And then there was another master, Master McBride, who almost hit a lawyer with a leg of a broken chair and chased him out of the courtroom. So all kinds of crazy stuff happened back in the day.
I thought I'd heard all the stories, but I never heard that one.
Yeah.
So,
Yeah, no
so
one.
aside from
My first day articling, I got to tell you this story. I was told
please.
to go to Master McBride to have him sign an order, and I didn't know who Master McBride was. And there was a nice Master McBride, Sam McBride, did family law, and then the taxing master, which sounds like a slave driver, was KC McBride. So I went to KC McBride and the master, and I said, "I have an order for you to sign, sir." And he said, "Oh, let me see it." And he looked at it and he said, "Oh, you got the wrong Master McBride. The right Master McBride is down the hall and 3 doors." So anyway, that was it. And I went to see Sam McBride, who of course was a jovial fellow, and he signed the order. And I went back to the office. I told him I appeared before the wrong Master McBride, and everybody thought, "Well, where are your scars and the blood and the bruising that most people get when they appear in front of this guy?" So courts have become more respectful of counsel and more tolerant of people who don't know all the rules of evidence. But practice is probably a little, I don't know. I don't know if standards have gone down or what, but people used to, out of fear mostly, be very well prepared when they went to court. And nowadays, a lot of people on various cases are not as prepared as they need to be. And they're not given difficulty for doing that. And but anyway, the main change, of course, is technology, and
Right.
and certainly with COVID, we were forced to move online, and Zoom is a
Yeah.
great medium for that. And the courts are sticking with it. My 2 days of court were, one of them I did from my cottage, and the second day I did from my secondary office here in Oshawa, where I am right now. And usually you have to go to the court, but you can do it from just about anywhere you have high-speed internet. Very
Yeah,
convenient.
that's. I know we were talking about this a little bit before we started. I mean, I've been very critical over the years of our profession and how reluctant they were to adopt technology, and certainly things like remote work. So that was one benefit of COVID. So I'd be curious what your thought on this. So you've been practicing for about 43 years now.
That's
Uh,
right.
so has there been more technological evolution in the last, let's say 4 years or the 40 years before that?
Well, this process of change is definitely speeding up more. So people were very reluctant to accept technology when it first came to them, and that's in the legal profession. And I think again, it was COVID that forced us to become computer literate, because up until then, many lawyers didn't even have email addresses. Mostly it was the older practitioners who thought, well, I won't need it. And those guys have all retired or gotten their email addresses and have to deal with it. But the rate of change is accelerating. And I think that because of the speed of the internet, and because of the improvements of software, we're able to do so much more than what we did before.
Yeah, which it has been a game changer. And I have to laugh. So I was called to the bar in 1999, and I was at a large downtown firm at the time. And I remember, it wasn't, and this is hard for a lot of the younger lawyers or viewers to imagine, it wasn't a given that you would have internet access from your computer at your desk when I started. But the messaging in my firm was that if you wanted internet access, you could ask your practice chair. And I assumed that would be a rubber stamp, but I still remember, going down the hallway to my practice chair, who is still a friend to this day, and I still make fun of him about this, because when I asked him for internet access, assuming that he would say, "Sure, I'll make it happen," he kind of leaned back in his chair, as older lawyers tend to do, and took a deep breath, and then explained that I could plan my vacations on my own time, and there was really absolutely no reason for a lawyer to have internet access while they were trying to get work done. So
yeah,
that was when I started.
Changed too. When I started, we'd ask the managing partner if we could have a couple sticky pads so we could write little notes and put them somewhere so we can remember to do things and do mark things. And they rationed them to us. They wouldn't let us have more than a pad a month or something like that. And that was like back in the days when you dictate into these machines. And when I was articling, they had this blue plastic thing that was like making a record when you dictated. And then,
Right.
of course, the secretary to transcribe and do all your letters. So the amount of staff you need to do things has certainly gone down. And lawyers have many firms, lawyers don't have any assistance at all, and do everything themselves. And it's a lot easier now because of the software that exists.
Yeah, no, it's amazing how it's changed. Although I have to admit, in some ways, I think I'm reverting back. I've actually started dictating again recently, because I was always very techie and I could always type very quickly. But I realized it's still a lot more efficient for me to dictate something than to sit there and try to type it. So I've been doing that more often recently.
Yeah, different things work better for different people. I like to self edit as I go, and I go back and forth. And if I'm dictating, I have to make too many changes on the go, so it doesn't really work for me. So if I'm at my laptop, or even I still use desktops, I prefer them. I do tend to create Word documents and keep changing them as I go. And if I did it another way, it would be less efficient. So there.
Yeah, and I've kind of gone back and forth on that. But anyways, I don't want to digress too far into how I
get
practice.
boring if we do. So let's talk about
we can talk about that.
Employment law. That's your thing, isn't it?
Yeah, well, employment law and a bit of ADR. Because I know, one of the things we haven't, you mentioned when we've talked about in the past. You've been doing ADR, I think, since the mid '80s. Is that right?
Exactly. January 1985. I didn't know anything about ADR, and I was asked to teach a course in arbitration. Not just a course in arbitration, but an advanced course in arbitration. So luckily, I had about 6 months lead time to research and prepare for this course, which, by the way, included, at least I put it in, I made it part of the course, a major section on mediation, because nobody was doing mediation back then, and I'm talking 1984, 85, except in family law. But I noticed that in the US, they were using it in all kinds of litigation and beyond family law. And obviously it's grown a lot. But I worked with an employment lawyer named Howard Levitt at a law firm back then that was called Aiken Cap. I was a personal injury junior at the time. And Howard was just a year ahead of me, but he was making more money than anybody else at the firm. But they didn't want to make him a partner. So anyway, he was a lawyer for the Association of Professional Engineers Ontario. And they were very involved in arbitration, as were architects, real estate appraisers, people in the construction industry, and real estate appraisal. That was the main area for arbitration. It's certainly broadened since then. But anyway, Howard Levitt brought me in to teach this course, and I still thank him because he really started a career for me. And I've been teaching arbitration. My next course comes up in October. It'll be a hybrid course between in-person seminar format, and there'll be a big screen where we'll have all the people who are participating by Zoom in the course.
That's always,
so
I've
we're
done
going to
some
try to
courses
integrate
hybrid.
that, and then it's going to be interesting because we haven't done that one.
Yeah.
before.
I've done some courses on a hybrid basis. It's definitely a challenge, but it's the reality. But I'm curious, it's interesting because in the employment law world, as opposed to the labor law world, which for people who don't know, labor law is the unionized context, employment law is the non-unionized context. It's the norm in the unionized world that you have grievance arbitrations, and pretty much everything is dealt with by arbitration. And yet in the employment law world, it's extremely rare that we use arbitration, despite all of the inefficiencies of the court system, which we can talk about. But I guess I'd love your thoughts as to why you think that most employment lawyers don't even think about arbitration, and then we could talk about why they should.
Well, the first point is most lawyers don't think about arbitration. It hasn't progressed like mediation has, because mediation, that people can try to close a file through mediation and move it along, but arbitration, most lawyers have no idea still what arbitration is. And in many arbitration proceedings that I preside over, the lawyers are trying to treat it exactly like court, or else they're trying to treat it as if it had no rules at all. So there's no training in law school. Maybe there's some optional courses in arbitration. And if you take an ADR master's degree program or something like that, it's 95% mediation and maybe 5% or 3% arbitration. So arbitration is still not a very well-known process, but I think it is the way of the future. And online arbitration is way cheaper than in-person arbitration. And the movement in arbitration has been to online, because you have all these people all over the world who could be involved in your case. And you have to bring them all into Toronto for a hearing, or Vancouver. Vancouver is a major arbitration center. If you have to bring them all to one place, it's going to be very costly between their travel expense and all the extra time you have to bill for. And then in arbitration, the costs that can be ordered to be paid by an arbitrator can be way higher than the costs in court, because costs includes everything, including the fee of the arbitrator, whereas in court you get a free judge.
Yeah, you get a free judge, which sometimes you don't get a judge that you want, but you get a free judge. But you made an interesting point I wanted to come back to, because this is one of the criticisms I've heard a number of times, is that when people actually do consider arbitration in a civil dispute, they often just say, well, the rules of civil procedure will apply. So they basically just take the court process and do it in a private scenario. Whereas one of the really great advantages to me of arbitration is you can really customize the process to the case you're dealing with. And I won't say do anything you want, but almost anything you want. So what might be helpful, actually, because you're right, most people aren't familiar with this. So how does it work? If there's a wrongful dismissal claim, and instead of rushing off and filing a claim in court, both parties or both counsel agree, we're going to arbitrate this. What happens next?
Well, first thing they do is pick an arbitrator, and they can pick someone who actually knows something about it, like another employment lawyer who knows where it's headed and knows what is a reasonable decision. And if they don't follow early signals of that arbitrator, which are usually to be followed, then they will end up with an outcome that could be very unpleasant for them, depending on their position. But in a situation where you have an expert arbitrator who's an employment lawyer for an employment case, I think there's a much better chance of getting it settled, just as if you had a personal injury lawyer mediating a personal injury case, and they're willing to give an opinion, which some are not in mediation. They just stay quiet and, what do you think? What do you think? And they don't want to tell you what they think. I think in mediation is the place where the mediator should be giving an opinion. And arbitration is where they better be careful not to, but which brings up the topic of MedARB, which is an area where I'm fairly well known as an opponent of the MedARB process, generally speaking, because I think once you as mediator know what people are really looking for and how much they'll take, how can you go on from there to make a decision. Somebody's asking for $1 million at the hearing, but they would have taken 25,000 in mediation. Can you really take their claim seriously at that point?
Yeah, well, and that's a whole other issue, which I think is interesting to talk about. And just in case anyone's not familiar, MedARB is the nice combination of mediation and arbitration, which can be done in different ways. I mean, I think that the typical way that people do it is you have a mediation first, and if you don't settle, your mediator takes off his mediator's hat, puts on his or her arbitrator's hat, and now you have an arbitration. And to your point, there are a lot of people who say that they can't be neutral or objective at that point, although there are a number of people who say otherwise. Um, if you had to be devil's advocate for the moment, what are the advantages of MedARB?
Well, the mediator has more clout, but that's more than anything. If the mediator expresses opinions or hints and directs people at mediation to what they may think, they're far more certain to settle at mediation. And what I've seen in MedARB is many times where they don't settle at mediation, the parties agree to get another person to arbitrate, or the arbitrator disqualifies themselves because they know too much. They know things that aren't evidence, and they shouldn't know those things. The arbitrator, there's enough mediators around that you don't need people to do both. You have somebody mediate and another person arbitrate. That is a good way to do it. And hopefully you don't have that many arbitrations if you have a good mediation first. But
I think that makes sense.
I've known it to go bad, and I know the courts on appeal have overturned many MedARB decisions, far more than they have overturned other typical arbitrator type decisions. So it is a dangerous.
I think a lot of mediators or arbitrators have an opt-out clause. So any of the parties or the mediator or arbitrator themselves can opt out after the mediation is done if they're not comfortable proceeding, which I think makes sense for the reasons you said. I've heard something suggested in theory, I've never seen it in practice, where one of the ways to avoid this whole lack of neutrality or the arbitrator knowing more than they should is to do the arbitration first. So the scenario is you have your arbitration hearing, the arbitrator renders or shouldn't render, they reach their decision, they write it down in a sealed, put it in a sealed envelope, and it's kind of sitting there on the desk, and then you mediate. And the understanding is that if we don't settle by 5 p.m. today, then they're going to tell everyone what their decision is. And I can see how the pressure would be great, because normally at mediation, we're saying if we don't settle, we're going to keep going down, and a year or two from now, we may have a trial. Whereas in this case, at 5 o'clock today, we're going to have a decision. So have you ever seen that done?
No, not that, but it made me think of final offer arbitration, which is what they do in baseball and some other sports, where each party is careful not to ask for too much, because they think then if I ask for too much or I offer to pay too little, the other party's offer will be the more reasonable one. And what often happens is the parties come so close together that it's effectively a reasonable settlement. To me,
I think it's great. It's a great approach. We often refer to it as baseball arbitration for that reason, but it forces both sides to be reasonable, because the arbitrator's got to pick one or the other, and often it's the less unreasonable side that wins.
Years ago they had a thing like that. It was online. It was for personal injury, where the plaintiff and the defendant each make their best offer through some service, which takes a commission out of you, and basically what happens is they end up settling. I forget how they end up settling it. Do they take the final off the close? I think they merged the two offers together in some way. And anyway, it seemed to work for a while, but they went out of business at least 15 years ago. So I guess it didn't really work too well. But I had good settlements that way, and I had insurers offering me more money than I was asking for in some cases when I was plaintiff lawyer. And that made it a lot easier. We got some surprisingly good settlements.
That's interesting. So I know when we met a couple of weeks ago to talk about this, you mentioned some surprising elements of the Arbitration Act, because as everyone should understand, if you're going to arbitrate, you're governed by the Arbitration Act. So I wanted to give you a minute if you wanted to mention any of those surprising elements you were thinking of.
Well, the Arbitration Act is based upon uniform law put up together by the United Nations Committee on Commercial Arbitration. So what happened was we had an old law of arbitration that was written in the 1800s. It was hard to understand. There were like sentences that were 15 lines long without a comma, and it was really hard to understand it. So they changed it to a plain English act, and I think they oversimplified it in some ways, and they didn't think of a lot of things that do come up, and there are some weird things there, such as if you have three arbitrators, and there is a decision, if there's a split, then the chair gets to decide unless the parties have opted out of that provision. And then there's things like that the trying to think what this is now. The decisions can be appealed only on error of law with permission of the court, unless you provide other grounds for appeal in your arbitration agreement. And most of the people don't really think about these things. They don't prepare an arbitration agreement. And they just let it go by this default and end up with something that they don't like because they don't know what the law is. I've had arbitrations as long ago as 10 years ago where people pulled out their Arbitration Act from the last revised statutes of Ontario in 1990, came out in a book, and it's the old Arbitration Act that was repealed in 1991. And so people just have no idea what they're doing, especially lawyers who think they know stuff and they don't. People tend to be overconfident and they don't really prepare for this arbitration process. But all in all, the Arbitration Act is pretty good, and it gives a good guideline and it gives you the ability to opt out of provisions that the parties agree that they don't want. One of my favorite things to do when you talk about civil procedure rules, they adopted it for their arbitration. The one rule I like to adopt from Ontario is Rule 49, offers to settle. Because in the Arbitration Act, it's a really crappy provision that the arbitrator may take into account offers to settle. Whereas in the court, the arbitrator shall take into account offers to settle. And I think that's a lot stronger, giving a stronger incentive for people to settle their cases. So there's a lot of nuances too, but you're gonna have to take my full course to learn about it.
No, I think that Rule 49 offer, which it's funny, actually, I was just talking about that with one of my associates about an hour ago on a file we're working on. It can be very strategic, to simplify it somewhat. Essentially, if you make an offer to settle a case and you beat that offer at trial, then you get more of your costs or have to pay less of the other side's costs, depending on how it plays out. But it can be very, very strategic. So we, as always, time is flying by. So before we wrap it up, I wanted to ask you, you talked about the fact that most lawyers just aren't familiar with arbitration, which I think is a very fair point. We've talked about how it can be customized. When you are arbitrating, either as counsel or as arbitrator, how often do you see the parties actually taking the opportunity to customize the process as opposed to just kind of going through the same old process that they're familiar with?
Well, I think lawyers like using precedents. So they find a precedent agreement and they go with it. And if the precedent they find is one that is innovative and helpful, then they will use it. But it's very rare that the lawyers will actually sit down together and work on how they want to do things, because there's so much potential to make for an effective, efficient process designed exactly for this case. And that's the way it should be done, I think, in many cases.
Yeah.
And people don't do that. They're lawyers tend to be lazy and they tend to follow precedents that they have of arbitration agreements, or they have no arbitration agreement at all. I probably have had more arbitrations where I've been arbitrated where there's been no arbitration agreement whatsoever.
Yeah, I'm not surprised to hear you say that. Well, before we wrap up and I take my turn to fire away, any parting thoughts, and also let viewers know how they can find you?
Oh, okay. Well, back in 1997, there were very few legal websites in Canada, and one of them was my website, which was adrworks.com, because I emphasized ADR in my law practice. We've now changed our law firm website to ADR Works. Sorry, it's not ADR Works. It's miskinlaw.ca, because more and more people are learning how to spell Miskin properly. But because originally I was worried about people putting an H in Michigan or whatever I tend to be called. But we now have adrarworks.ca, which is my ADR website. They didn't have .ca when I started, or I might have got one. But adrarworks.ca, they can learn about my services and the arbitration course. And again, there's one starting the first time ever hybrid. We've been doing them on Zoom entirely the past 3 years since COVID. We stopped for a year because of COVID, and I said, COVID will end, and then I'll come back to an in-person course. And COVID stuck around, and here we are now with the hybrid course, because nobody wants to go back to in-person. Most of our students who've signed up for this course want to do it online, even if they're in downtown where the course is offered, Toronto. They'd rather do it from their home or their office or somewhere else where they can multitask, I assume. And anyway, so I do encourage people to get some training, or at least read the Arbitration Act if you want to know something about arbitration. And I really do enjoy mediation as well, but arbitration is an area where there's a lot more opportunity because there's a lot less people doing it. And I do believe that there'll be a shift to arbitration from court, whereas the shift to mediation has already happened.
Yeah, I think that's a great parting thought. So Murray, thank you again for joining us on the show today.
My pleasure. Thanks for asking.
All right, well, now I'll take my turn to fire away. So I've been practicing law for about 25 and a half years now, primarily dealing with litigation, especially in the first part of my career. And one constant is that in the world of employment law, and certainly amongst the employment law bar and the litigation bar, we are always complaining about the litigation process. We complain that the courts are too slow. I used to tell people that it would take a year to 2 years to get to trial. Since COVID and with the backlog we have, it's now more like 3 years. And if you think the tribunals are any better, the Human Rights Tribunal is tremendously backlogged. And actually, just last week, one of my colleagues posted on LinkedIn that he received notice from the Human Rights Tribunal of Ontario that they had just processed a complaint that was filed in 2019. And for the record, I'm recording this in July of 2024. So it took almost 5 years just for the first step to take place. And we're often telling people it's going to take you 5 years to get to a hearing in the Human Rights Tribunal. So whether you're talking about courts or tribunals, they are tremendously slow, and we complain about it. We complain about the fact that it's a one-size-fits-all approach, which doesn't really make sense. And getting back to what Murray, Miskin, and I discussed in Season 7, Episode 6 of Fire Away, doesn't make sense to use a full-blown litigation process with exchange of documents, examinations for discovery, and then a full drawn-out trial with all live evidence when you're dealing with, for example, a pure wrongful dismissal notice case where there's no facts in dispute. The only question is, what is the severance period, and how do you quantify that in terms of dollars? We complain about the unpredictable results we get from judges or juries, often because you end up with a judge who is not intimately familiar with employment law. We often complain that the court system or the tribunal system is public, and a lot of parties don't want it to be public. We complain about the inefficient days in court, and again, going back to Season 7, Episode 6 of Fire Away, we had to delay by a day because of some of the inefficiencies that our guest, Murray Miskin, had to deal with. And we complain that judges and adjudicators have no room for flexibility or creativity when it comes to their remedies. So we complain a lot about the court process and the tribunals. And yet, despite the fact that all of those issues can be addressed through ADR, alternative dispute resolution, we almost never consider arbitration as an alternative. As counsel, and I'll let myself into this group, there's a dispute, we'll try to settle it. If we don't settle, then we go and file the claim in court, and we start down litigation path. So I'm just encouraging everyone as part of this rant to be open to the fact that there are alternatives, and arbitration is certainly not right for all disputes, but neither is our court system. So if you are a counsel watching this, before you file the claim, consider whether arbitration would be better. And if you're a party, if you're an HR, if you're a business owner, if you're an individual involved in any kind of dispute, especially an employment dispute, ask your lawyer whether they've considered arbitration as an alternative, because you can choose arbitration and then customize the process and deal with the matter far more efficiently than you could using our courts, or the tribunals. So take the time to think about it before you just proceed, as you always do, and then complain about it later. Thanks for listening. That's a wrap on Season 7, Episode 6 of Fire Away. Our next episode is going to be on August 20th, and we're just finalizing details in terms of the guest and the topic. But I want to thank everyone for tuning in today, and I want to thank Murray Miskin again for being a guest. And as always, thank you to Rob, Rebecca, and Mark for helping put the show together. And to quote one of my favorite hockey broadcasters, the pleasure was all ours.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.